deals with two particular topics. One is consent scheme and non-consent scheme. The other is DMC. Okay, consent scheme and non-consent scheme. The more important one is consent scheme, because consent scheme is mandatory. Non-consent scheme is voluntary. Now, in Hong Kong, consent. In fact, I think Hong Kong is, as I said, Hong Kong people are really crazy about real property. So that was quite a new idea that you can purchase unfinished development, in the last century, and that was somehow invented by people in Hong Kong. In the past, no one would sell unfinished developed units to individual purchasers. Now, of course, nowadays everybody is doing so. The British new flats are sold every week. You go to Mandarin, you go to whatever hotel in Hong Kong during weekends, you will come across all these kind of sales. But in 1961, in fact, it was introduced in Hong Kong. It's the first thing happened in the world. The reason was that at those days, the developers in Hong Kong is not as rich or as wealthy as they are today. They usually would not have enough money to fully complete a development. So after they got a piece of land from the government and try to build on the land, they may not have enough money, so they want to sell the unfinished units to potential or future purchaser to get their money to fund the development. But in many cases, those developers could not complete because they did not have enough money. Now, the problem is, in the condition of sales from the government, there is always a condition. You cannot, the developer, meaning the developer cannot alienate, that is, they cannot sell any of the interest of the land before completion. So you must have the entire building finished before you can sell it. Now, for those developers who sell the unfinished units to purchaser, such sale and purchase agreement could not be registered in the land registry. Because if you register, you are telling the government that this developer is in breach of the condition. Then the government is likely to re-enter. So there was a common understanding between the developer and those 買樓花 purchaser. We sign, and then we can keep it in the solicitor firm, but we can never register it. Because once you register, that's the end for everyone. Well, on the other hand, the government allowed the developer to mortgage their property to a bank for funding to construct or to construct the building. If the developer did not have enough money, and this is because the mortgage is approved by the government, the bank can register the mortgage against the title. So whenever the developer had financial problem, the bank can enforce that charge. Of course, in those days, it was mortgage. Enforce the mortgage against the developer and get the development. Whereas those purchaser who has paid money to the developer, but their contract was not registered. We just learned about Section 3 and 4. Even the bank was aware such sale and purchase had taken place. They were not bound by them. Therefore, at the end of the day, it was the purchaser of those unfinished units suffer. And in the past, we have an example in which the developer asked those purchasers, now, if you do not pay more, you got nothing. So everybody please pay more. And we have an example called Peony Garden, in which the purchaser will require to pay 30% more in order to have enough fund for the developer to pay back the bank and get the development to continue. Therefore, the government said, well, if we allow this to happen, then it would just create trouble. Those purchasers would, of course, come to the government for help. Therefore, at the end, in 1961, now this is the example I just mentioned, Peony House, West Block, 259 purchasers were forced to agree to pay extra 30% for the developer to complete the building. If they did not pay, they got nothing. Therefore, they had to pay. So the government invented consent scheme to give a permission for the developer to sell unfinished units. But if you want to sell, you get my consent first, get the consent of the government. And in order to satisfy the government under the consent scheme, then the developer has to satisfy a number of requirements. The consent, in theory, or in practice, I should not say in theory, in practice is to be given by LACO. We learned about this particular department in Lands Department. It is a legal advisory conveyancing office to give the consent to developer to sell unfinished units. And the basis for giving consent is sufficient evidence of financial ability of the developer to complete the development. And well, in 1960s, there were 3 requirements. Developer must have already made at least 30% of the entire investment. Developer satisfactorily demonstrate that it had the financial ability to complete the project. Now, usually, they will require a bank to guarantee that they had financial ability. And the sale and purchase agreement for the P-sale was adopted standard terms and conditions prescribed by the Lands Department. In fact, the LACO designed the sale and purchase agreement for Mai Lau Fa, for the P-sale of unfinished unit. You have to adopt the agreement. Otherwise, government will not give you consent. Now, of course, since 1961, there have been many changes. And changes were also introduced when the property market in Hong Kong was booming and when it went down as well. So if you want to know what was the existing consent scheme, you have to consult the website of Lands Department. But basically, the 3 basic elements still exist. And the most current consent scheme has the major condition as follows. First of all, the premium for the land must have been paid before the consent be granted. So the developer has to pay the premium first. And developer cannot use the property as security to borrow money for payment of the premium. Now, you are now to use the property as security to borrow money for construction costs only, because construction costs, when compared to the premium, was just small potatoes. And nowadays, the power to mortgage the property to finance the development is often part of and subject to the condition of sale. And the developer must show satisfactory evidence of financial ability to complete the development. But of course, nowadays, most of the developers in Hong Kong are very, very powerful and rich. So for that part, you really do not have to worry too much. Developer solicitor must make a statutory declaration. So even the solicitor has to play a role in the consent scheme. They have to make a declaration, statutory declaration, saying in relation to the sale and purchase agreement, they have to say, we adopt the sale and purchase agreement designed by LACO, and we have already drafted the DMC, because nowadays the government keep a close eye on the terms of the DMC, so that more protections are given to individual owners, co-owners of the building. In the past, the DMC, well, in fact, even today it is the same. DMC was drafted by the developer, so developer would leave to him all the rights, but without liability in the past. And now this DMC has to be shown to the lands department, and if lands department does not approve the DMC, then they will not have the consent for selling future, unfinished units. Building contract and other documents to be there, for the government to examine. A certificate in relation to number 5 below, in fact, it talks about the building plan has been approved, etc. And the certificate date 3 calendar months before the date of application for consent. And this number 5 would be, first of all, the foundation of buildings must have been complete. And building authority must have given consent under Section 14. Remember, Section 14 is the important section, because any building work, before it take off, it must get the approval of the building authority under this section. Draft agreement for sale and purchase must be attached. Again, to say this agreement must be approved. So, in fact, every solicitor would just copy the agreement prepared by LACO. And if you want to have your own sale and purchase agreement, it's all right, but you must have all these terms in the agreement. So the developer must give warranty to the fitting and fixture and the standard of work. Identification of area now by what we call the saleable area. Warranty that the building plan has been approved and consent to commence building has been given. Give a specific date by which the construction is to be complete, and then in default of which purchaser is entitled to receive the sale and purchase agreement. But this particular date is somehow misleading, because if there is an architect, of course the architect was the approved architect, to certify that, because the weather during the construction period was not good, we have so many rainy days, the construction work could not carry out, therefore there was delay. If the architect certified certain delay was normal, then even the completion date fall behind this specific date, the individual purchaser would have no remedy. But at least, there was a specified date or in the sale and purchase agreement. In theory, if the developer failed to complete the entire work as on this specific date, the purchaser of those unfinished units could cancel the agreement. So from the advertisement nowadays, you can always say, 第一個關鍵日期, all these so-called, specific are referring to the specific days in the sale and purchase agreement. the need to obtain an occupation permit before completion of the contract. So you must get the occupation permit before you ask the purchaser to pay all the balance of the purchase money. Now, under this consent scheme, now there is no nomination, subsale, or transfer. Right? As we said, under normal second-hand sales, the purchaser can nominate a nominee to become the registered owner. But if you're talking about sale of unfinished unit, no, you're not allowed. You are not allowed to sell as a confirmed or subsale transfer of benefit before completion. And only the person who signed the preliminary sale and purchase agreement can sign the sale and purchase agreement. That is the formal sale and purchase agreement, no nominee. And later must be registered within 1 month. Time is of the essence, is always in all sale and purchase agreement in Hong Kong. Terms of agreement could not be varied without the consent of the Lands Department. Now, as I said, the consent scheme is subject to modification from time to time, and the most updated one is governed by LACO Circular Memorandum number 7272A, 72B, CD, and 80. Okay, you have to check if you are really working as a practicing lawyer to find the latest requirement for the consent scheme. Now, consent scheme is made possible because the government can put this requirement of consent scheme as a condition of sale. And what about what we call redevelopment of some old land? In the old part of Hong Kong Island particularly, there were some old buildings, 6-story high or even lower, and some developer was able to acquire all the interest, so they can knock down this old building and redevelop the piece of land into a high-rise building. Now, if that's the case, the government could not say, if you want to sell any unfinished unit, you must get my consent, because the government has no right to insert any condition of sale there. And this non-consent scheme is actually introduced in 1980s by the Law Society, and the Law Society did that. It was as a response to the request of the Consumer Council. The Consumer Council said, well, for redevelopment, there was no such consent scheme. The purchaser would not be protected. And therefore, the Law Society said, well, we would then develop the non-consent scheme. So whenever a developer gets a piece of land for redevelopment, they would not be required to get the consent from the government, but they would subscribe the non-consent scheme, so that the purchaser of those unfinished units would also be protected. Now, basically, there are 3 conditions for the operation of non-consent scheme. Consent scheme does not apply. That means no condition of sale from the government. Sale and purchase of part of an incomplete building of residential unit. So non-consent scheme does not apply to commercial unit or industrial unit. Only consent apply to residential unit. And the same solicitor represents both the purchaser and vendor, because only when one solicitor represents purchaser and vendor, that this solicitor can exercise control over the sale. And the Law Society promulgate the non-consent scheme under Rule 5C of the Solicitor Practice Rule. And the basic format is model on the consent scheme. So there must be a standard sale and purchase agreement, and in fact, most solicitors would adopt the sale and purchase agreement approved under the consent scheme. So solicitor also have to make a declaration as required under the consent scheme. So basically, this is consent scheme and non-consent scheme. The other is about DMC. DMC, deed of mutual covenant. It is, after all, a contract under seal, made among the developer manager as appointed by the developer, and the first purchaser of a unit in a development. But this particular contract is binding on all subsequent co-owners because it is actually contain mostly land covenants, and land covenants overcome the doctrine of privity of contract. The main function of DMC is for the manager to make house rules for the entire building and to regulate the rights and obligations of individual co-owners of the building. Now, it is a contract. You cannot have an illegal contract, right? So you cannot just say, well, I'm the developer, I want to draft certain terms in the contract for the benefit of majority of co-owners. But if those clauses are in breach of Hong Kong law, then such clause would not be enforced by the court. Now, this is a very good example. Grace International Limited and corporate owner and Fontaine Gardens. So Grace International Limited is one of the co-owners in Fontaine Gardens. They fail to pay management fees. Under the DMC, the manager can cut off water supplies to a unit if the owner fail to make financial contribution to the incorporated owner. So in that case, Grace International Limited, being one of the co-owners, did not make certain payment to the IO, and therefore the manager stopped the water supplies to that unit. Of course, this is a very powerful weapon, so to speak. Without water, you cannot live in that unit or rent it out. But the co-owner, Grace International Limited, sued the incorporated owners and said this particular provision in the DMC is illegal and not enforceable. So they sue and try to get an injunction from the court to restrain the manager from stopping the water supplies. And the court held that only water authority, because in Hong Kong, only water authority, 水務處, has power to disconnect water supply to a unit. And even though they have power, they have to observe the conditions in the Waterworks Ordinance. And under this ordinance, no one was authorized to cut off water supplies, not to mention a manager in a building. And therefore, the court grants the injunction to the owner. And of course, that means that particular provision in the DMC was not enforceable due to illegality. Now, typically, an DMC would contain the following provision. First of all, they will give the details of the developer as well as the title in relation to the land that the developer obtained. Now, remember, all co-owners only are allocated with equal undivided share. So basically, the developer would distribute the equal and divided shares to individual owners. And in fact, the number of equal and divided shares usually would be corresponding to the share of management costs. If you have a bigger unit, exclusive possession to a bigger unit, you would be allocate more number of equal and divided share, and you have to pay more management fees. And the exact number of equal and divided share attached to a unit forms part of a good title. So if you're purchasing a multi-story building, unit in a multi-story building, if your vendor cannot tell you how many number of equal and divided share would be allocated to you, then he fails to give and show good title. Now the leading case is this one. Vendor sold a shop on the first floor. Now this is also an example in which the vendor, in this case, purchased the entire first floor, and we cut the number of units on that floor into different number. Now, for that particular first floor, the total number of equal and divided share allocated to that floor is 85. And I mean 6 of 85. They only got 6 units given to that particular floor. And in fact, in the original plan, there were only 6 shops in the first floor. But this vendor, locked down the partition of the first floor and converted into 9 shops. But he did not allocate the shares to these individual 9 shops. So when the purchaser entered into agreement with this vendor for one of the shop, and after he got all the documents, he wondered how many units was allocated to the shop he intended to purchase. And the vendor could not give him answer. And the court, and he refused to complete. And the court held that the requisition as to the number of undivided share attached to the shop was rightly raised by the purchaser. And the vendor failed to answer this requisition, also failed to give a good title. So always remember, when you purchase any unit in a multi-story building, make sure you know how many number of equal and divided share you have. Now, of course, once you are given certain equal and divided share, for example, in the TV example, I got the first floor, I got 6 out of the 85 units. I can, subdivide that floor in smaller units, and as long as I allocate a certain number of equal and divided share to each unit, is all right. But in terms of common parts of the building, nowadays the common parts would also receive certain number of equal and divided share. Now, the common parts could not be dealt with by individual owners. They have to be dealt with by the incorporated owners. Because under Section 16 of BMO, Building Management Ordinance, once the owners have been incorporated, when you have an IO form, the rights, power, privilege, and duties of the owner in relation to the common parts of the building shall be exercised and performed by liability of the owners in relation to the common parts shall be enforceable against the corporation to the exclusion of the owners. So, unless there is no incorporated owners form, once the incorporated owners form, then the incorporated owners would be the only entity to deal with the common parts. If there is anyone, for example, trespass on the common parts, it would be the IO to bring out any action to eject those trespassers. And if someone, suffer personal injury, for example, in the common part of a building, then that injured person, if they want to get compensation, they cannot sue any co-owner. They have to sue the incorporated owners. And remember, the equal undivided share allocated to you represent that you are one of the co-owners. If you do not possess any equal undivided share, even though you occupy certain space in a multi-story building, you are only having a license to occupy that space. Remember the case about Chongqing building, when the co-owners actually create some unit in the common parts. Of course, that this occupier only have a license. Now, the DMC also deal with rights of individual owner. Now, this is particularly important when the building consists of both residential and commercial units, because owners at the residential and commercial unit may have different rights and obligations. In fact, next month, I have a case. I'm seeking appeal from the Lands Tribunal in relation to my client, who is the owner of the commercial unit, and against the owners of the residential unit. They always conflict with each other, even though they are co-owners. Their rights are different. Now, in this particular case, Grove Bright Limited and Incorporated owners of Grandview Building, the appellant was the owner of the commercial unit, which occupied the first, second, and third floor of the building. And there were two residential lifts, but these two lifts did not stop at either of the floor. The owners of the commercial unit were not required to pay any fees for the lift service because, the lift did not serve their floor, therefore they were not required to pay any fees. But because they want to attract more customers to shop in the free floors, they apply for breaking the open shaft walls of the residential lift and install lift doors at the opening so that one of the lifts could be used by the visitor to the first, second, and third floor. And then in that case, the rental value of those 3 floors could be increased. Now, under the DMCs, the owners in the commercial unit have a right to use the residential lift for certain purposes only. For example, they may use the lift to go to the roof to or fix something. And the appellant in that case therefore argue that they have an implied right to break open the residential lift shaft and install the doors at the first, second, and third floor. But the trial judge refused such application, saying that the design of the building to begin with did not anticipate the use of the residential lift for the commercial floor. So this particular argument of implied right was not supported by the facts of that case. And they appealed. And the court of appeal held that in construing the DMC, explaining or interpreting the DMC, the court should take into account the physical state of the building and the construction of the building. That separates the commercial use from the residential use. And the court said that in the original lift shaft walls, there was no opening on the commercial floor. And not only that, the walls were constructed, talking about first, second, and third floor, construct double layers of material. So the court said that this is indication that in the very beginning, in the development of this commercial building, commercial residential building, the intention was the residential lift should not serve these three floors, and therefore they affirm the decision of the trial judge. Now, annexation of the DMC to the land. This is one of the function of the DMC, because DMC is, after all, land covenant. Once the land covenant annexed to the land, then they could be binding on all subsequent owners, even though at the very beginning it was only entered into between or among the developer, the manager, and the first owner. And I can guarantee the first owner is always the related party of the developer, because in that case, they can manipulate the entire DMC. Now, individual owners' right to the exclusive possession of the unit and the benefit for using certain easement, any reservation right, privilege, etc., would also be clearly spelled out in the DMC. And the right of owners to enter any part of the building to carry out necessary repair work subject to the consent of the manager is also a standard clause in the DMC. And now, this is important. Rights retained by developer in relation to the land. Now, if you look at certain buildings, the outer wall, particularly those in which the outer wall was being used for advertisement, now I can more or less guarantee that the right to advertise, to use the outer wall for advertisement rests on the developer. Because, you can have huge amount of income when the outer wall of a building is being used for advertisement. But this income will not go to individual owners, because under the DMC, this right is always reserved to the developer. In the past, when the DMC was not somehow regulated by the government, the developer even did not allocate any equal and divided share to the use of the outer wall, so that whenever there is any maintenance necessary, it is the co-owners who pay, but the money for advertising goes to the pocket of the developer. So in fact, nowadays, the developer has to at least allocate 1 or 2 units so that they would be required to pay at least some of the cost. The right of developer to name the building, of course, remember, we have come across a case said that this right is actually not a land covenant. From time to time, the right of the developer to name the building is within the DMC. An obligation of the owners to pay management fees, etc., would also be the important provision in the DMC. Now, this is actually how the court, how the government helped to regulate the DMCs. The 7th schedule to the Building Management Ordinance apply to all DMC. Now, in the past, when it was the developer who has the ultimate power to draft the DMC, of course, they would hire manager, which is their subsidiary company. For example, Sun Hong Gate always Kai Sing. So, in the DMC, there was no provision to allow co-owners, subsequent co-owners, to terminate the service contract of the manager. So the manager can just increase whatever fees they want to impose on subsequent owners. And there have been many such grievances made to the government. Ultimately, this particular schedule was enacted and annexed to the Building Management Ordinance. So they was introduced to eliminate harsh terms of the ODMC. Typical harsh term include owners could not terminate a contract of manager. And now, these are the mandatory terms in the 7th schedule. So first of all, in the DMC, the manager has the duty to determine the total amount of management expenses. They also have the duty to keep the accounts of all the revenue and expenditure. They must maintain a bank account. All the money should be deposited into a bank account and paid out from the bank account. Details of the contract that managers are able to enter without the consent of the incorporated owners. They can hire certain, for example, security guard. But if they want to enter into a contract to deal with individual building work, then they need to seek the approval of the incorporated owners. Requirement for resignation of manager, that means if they fail to do whatever duty, they have to resign. And when they resign, they still have to account for all the money they have been keeping. And there is also a statutory mechanism for terminating the contract of manager by the incorporated owners. Now, basically, the incorporated owners would have to call on a general meeting, and there should be certain percentage of owners present in the meeting and vote against or for or against the termination of the manager. But at least it is possible. Now, even though in those old buildings under which the DMC does not allow the owners to terminate the contract of the manager, this 7th schedule overrules those individual contractual provisions. Okay, and on termination of manager's appointment, they have duty to present the account to the IO, and all these important provisions in the 7th schedule were inserted to protect rights of individual owners against possible exploitation of the developer for the manager. And such term, is important. Such term cannot be excluded by agreement of the owners. So you cannot write in the DMC that, well, for our building, 7th schedule of the BMO is not applicable. No, you cannot do that. This is statutory provision imposed on all DMCs in Hong Kong. Okay, so that's all. So, okay, we're not really far away.